Agency and the practice of real estate. The topic of agency is one of the most challenging subjects that you'll encounter as a real estate licensee, as it affects all of your dealings with the public. In this review, we'll discuss several critical concepts related to agency as we look at the parties to an agency relationship and the duties of someone who accepts the role of agent. We'll see ways in which an agency relationship may be created, and how it may be terminated. We'll also describe different forms that a real estate agency may take and discuss an agent's obligations related to disclosure. We'll conclude with a short discussion on the topics of ethics and fraud. Before we begin, it's critical to note that this discussion considers agency from a general common law perspective. Each state has its own real estate agency laws that dictate the allowable agency relationships and the specific duties that real estate licensees owe to clients and other persons involved in a transaction. Always remember that your specific state laws supersede any of the general discussions we have here. So, what is agency? Agency is a relationship of trust created when one party gives another the right to represent them in dealings with third parties. This is a consensual relationship that both enter into willingly. When buyers or sellers, or tenants or landlords, hire a real estate licensee to represent them in a real estate transaction, for example, an agency relationship may be created. The individual authorized to represent the client, therefore, is known as the agent. The party granting the right of representation through an agency relationship, such as in a real estate transaction, is known as the client or principal in the relationship. Someone the agent works with, but not for, is considered a customer. Real estate licensees must take great care not to use the terms client and customer out of context or improperly, as it may imply a relationship not yet established. An agent may be classified in different ways, depending on the scope of authority. A general agent is authorized to represent the principal in a broad range of matters as specified, usually as part of a long-term relationship. A property manager is a prime example of a general agent. A universal agent is authorized to do anything and everything that can be lawfully delegated to a representative. Usually, such authority is granted through a power of attorney. Real estate licensees are rarely considered to be universal agents. A special agent has limited authority to perform a specific task or conduct a specific transaction. This is generally a short-term relationship. For example, when a real estate broker is contracted by a client to sell a house, the broker is considered to be a special agent. The authority to authorize an agency relationship may be expressed or implied. Expressed authority is given intentionally, communicated by the principal to the agent. Implied or incidental authority is the power to do everything reasonably necessary to carry out the principal's express orders. For example, a seller gives a real estate agent express authority to find a buyer for the property. This is understood to give the agent some incidental authority to market the property. A subagent is anyone given authority by an agent to assist in carrying out the principal's orders. Let's see how agency relationships may be created. An agency relationship is most typically established by written agreement but could be implied by the words and acts of either party. Implied agreements are difficult to enforce and often lead to misunderstandings that could result in litigation. A parent agency is created when someone who has not been authorized to represent another acts as if they are that person's agent. A parent agency can also occur when an agent acts beyond the scope of their authority, giving the impression the acts are authorized. This is also called ostensible agency. Agency by ratification is the later confirmation or approval of an act that was not authorized when it was performed. Agency coupled with an interest occurs when the agent holds an ownership interest in the property being sold. Remember that the payment of compensation does not create an agency relationship, nor does the absence of compensation mean that no agency relationship exists. Regardless of how an agency relationship is created, an agency relationship imposes certain duties, obligations, and high standards of good faith and loyalty on the agent as the representative of the principal. This can be described as a fiduciary relationship. Common law defines 6 basic fiduciary duties that an agent owes a principal: obedience to lawful instructions, loyalty, disclosure, confidentiality, accounting, and reasonable skill and care. It might help to remember these with the acronym old X.A.R. Loyalty requires an agent to put the principal's interests above all others, including the agent's own. Confidentiality requires an agent to protect any information that could reveal a client's negotiating position. The duty of confidentiality remains forever, even after the agency relationship ends. The duty of accounting requires an agent to safeguard and account for any money that belongs to the client. Reasonable care and skill require agents to be held to a minimum standard of competence. While fiduciary duties are reserved for clients, a licensee does owe customers certain basic obligations such as honesty, fairness, integrity, and disclosure of known material facts. An agency relationship may be terminated between a principal and an agent as a result of accomplishment of purpose, expiration, mutual agreement, renunciation, or revocation. Agency can also end by operation of law if a party to the agreement dies, becomes seriously incapacitated, or files for bankruptcy, if the property is destroyed or condemned, or if the broker loses their license to practice. Many different forms of agency relationships can be created. Remember that we continue to discuss agency in general terms. The types of agency relationships that are recognized in your state may be different. The most basic form of agency is when one agent represents just one party in a specific transaction. This is sometimes referred to as single agency or traditional agency. An agency relationship between a seller and a seller's agent is created with a listing agreement. An agency relationship between a buyer and a buyer's agent can be created with a contract such as a buyer agency agreement. Whether a seller's agent or a buyer's agent, a licensee has an ongoing duty to present all offers and counteroffers promptly. Note that an agent who represents multiple buyers simultaneously does not breach a duty or obligation to a buyer client by showing properties in which the client is interested to other prospective buyers. Similarly, a seller's agent does not breach their duty to a seller client if they show competing properties for sale to buyers who had expressed interest in the sellers. When both the seller and buyer are clients of the same brokerage, a dual agency situation may exist. While dual agency is legal in most states, a dual agent must remain neutral at all times and cannot advise either client on points of negotiation. A dual agent must be careful not to disclose confidential information from either client, especially if it relates to price or other matters that may adversely affect one of the parties. However, a dual agent is obligated to disclose material facts and defects, because this type of relationship might not be acceptable to one or both parties. In most states, dual agency requires the informed written consent of both clients. To address the issues related to dual agency, some states allow some form of designated agency. When a brokerage secures both the seller client and the buyer client in the same transaction, the broker may appoint specific agents to advocate separately for the buyer client and the seller client. Generally, the employing broker is still considered a dual agent, however. Some states allow a real estate licensee to assist in a transaction in a neutral capacity without providing fiduciary duties to either party. This may be called non-agency, transactional brokerage, or facilitational brokerage. Without an agency agreement, a licensee cannot advise nor advocate on the part of the consumer. Non-agency obligates a licensee to nothing beyond the duties of honesty and disclosure of material facts required for any customer. Most states require licensees to disclose the nature of the agency relationship into which a potential client is entering. Agency disclosure allows consumers to have full knowledge of the fiduciary duties owed to them, particularly how confidential information will be handled and shared. Ideally, licensees should disclose agency options upon the first substantive contact, before any confidential information can be shared. Many states require the use of a specific agency disclosure form. As mentioned earlier, disclosure is a fiduciary duty. Therefore, a licensee should disclose in writing to their principal any interest the licensee may have in the property. Additionally, when selling or leasing real estate that they own, licensees should disclose their licensee status before entering into an agreement of sale or lease. Such disclosure alerts clients and customers to possible conflicts of interest so they may choose to find another agent. Let's continue with the topic of disclosure and discuss material facts. In real estate terms, material facts generally refer to the condition of the property. In its broadest definition, however, a material fact could be considered any truth that would affect the individual's actions if it were known. Licensees must disclose known material facts. A seller and the seller's agent also have a duty to disclose known latent or hidden defects about the property to buyers. Some states impose an additional requirement to disclose anything that could cause illness or physical injury. While most states require sellers to disclose known issues related to property conditions, some impose the use of a specific property disclosure form. Real estate licensees should not assist sellers with completing these forms, but they should be alert to red flags that could indicate potential problems and advise buyers to follow up. Remember that the use of a seller property disclosure form does not absolve a buyer of all responsibility. The concept of caveat emptor, which translates to let the buyer beware, means that a buyer should perform due diligence and inspect the property before agreeing to buy it. A home inspection evaluates the quality and condition of the property, looking at the various systems, such as the roof, mechanicals, and the foundation. A home inspection is geared toward finding items that are dangerous or damaged, and items that don't work. While real estate licensees are required to disclose known material facts about a property's condition, there are some things that state laws may not consider material. A stigmatized property is property that may be considered undesirable because of a past event that occurred there, such as a crime or death. In most states, real estate licensees are not required to disclose issues unrelated to the condition of the property unless specifically asked. Note as well that it is a violation of the Federal Americans with Disabilities Act to disclose that an occupant of the property was exposed to HIV or diagnosed with AIDS. Also, a real estate licensee is generally not obligated to disclose information regarding sex offenders in the vicinity. Once sellers have actual knowledge, however, they should answer truthfully if a prospective buyer specifically inquires. If a buyer is concerned about the condition of the property, they can obtain, or ask the seller to provide, a home warranty. This provides some degree of protection from the cost of failure of appliances and major systems such as roofs and furnaces. Home warranties, typically paid as an annual premium, may provide for discounted repairs or replacement. As a real estate professional, you should be familiar with the importance of ethics in your daily life. Professional conduct involves more than adherence to the law. One can follow the law but not act ethically. Ethics refers to a higher system of beliefs, principles, rules, and standards based on values. Business ethics establishes rules that strive for a simple principle of what is right. Those principles may be a part of law, industry codes, company policies, or individual moral values. Real estate licensees have a duty to protect the public against fraud, misrepresentation, and unethical practices. Misrepresentation is simply false or misleading information. It could involve falsified documents, misstatements, or omission, which is failing to mention or disclose information. Misrepresentation is more than mere puffing, which is an opinion that is not necessarily intended as a representation of fact. Actual fraud is a deliberate act with the intent to deceive or with reckless indifference to the truth. It is any form of deceit, trickery, breach of confidence, or misrepresentation by which one party attempts to gain some unfair or dishonest advantage over another. Failing to disclose information you're required to disclose can also be a form of fraud. Constructive fraud, on the other hand, is a negligent misrepresentation or concealment of a material fact made unintentionally. Any type of fraud may constitute grounds for possible civil action for damages. As mentioned earlier, a material fact is generally defined as one that, if known, might have caused a reasonable person to make a different decision. Remember that real estate licensees have a legal and ethical duty to disclose any material fact that could affect a transaction. A licensee is generally not liable to any party for false information that the licensee's client provided to the licensee and the licensee in turn provided to another party in the transaction, unless the licensee had actual knowledge that the information was false or the licensee acted with reckless disregard for the truth. It is important to note, however, that an employing broker is generally legally liable for the acts of affiliated licensees and employees if the actions are within the scope of their employment, regardless of whether the employing broker knew about the actions or not. As you work in the profession every day, you'll see that nearly everything that you touch, every decision you make, every piece of paperwork you complete, and every conversation you have has an element of ethics involved. Ethics as it relates to a real estate agent may seem like a remember your fiduciary responsibilities. Disclose material facts. Don't take unfair advantage of people. Be honest with everyone. Treat everyone equally. Keep good documentation. That concludes this review. As a final word of warning, remember we've been discussing agency as it relates to common law. Your state has specific agency laws that define the acceptable relationships and your duties to your clients.